Hi, RERA, that is Real Estate Regulation and Development Act 2016, notified on 1st of May 2017. We are making this series on RERA where we are going to cover entire RERA Act. It's going to be around 15 to 20 part series. So if you go through it, you will get a good knowledge about the RERA. So today's topic is registration of real estate project. My name is Girish Rao. I am advocate and solicitor, having more than 27 years of experience, and I have registered more than 100 projects. This video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct various courses on the law, like mastery in drafting of agreement, mastery in drafting of pleading, mastery in RERA, and many other courses. If you want to know more about it, you can get connected to Legal Scholar Academy on the number which is scrolling here down. In addition to those courses, Legal Scholar Academy regularly on every Friday at 7:30 p.m. conduct webinar on different topics of law. If you want to attend those webinars, you can also get connected with them at the number which is scrolling down here. Now, let's start our topic. Before we start today's topic, it's a request to everyone to kindly subscribe to this channel, Legal Scholar Academy, where we regularly post videos on different topics of law, which are very informative and you will get a lot of knowledge. So I am requesting everyone to subscribe to this channel so that you will get a notification as and when we load a video. And other thing, don't forget to press a like button if you like this video. But I'm sure you are going to like this video. So now let's start the today's topic. Today's topic is registration of real estate project. In this topic, we are going to cover first is what is real estate projects, which project require mandatory registration, which projects are exempted from registration, and process of registration of the project and validity of the project. So these are the brief topics we are going to cover in today's this video. Now let's first understand what is real estate project, and this is very crucial for understanding what can be said as a project. Project is defined in section 2 subsection ZI and ZN. What does real estate project then covers? It covers one is development of a building, means basically construction of building. Development of a building consisting of an apartment, means normal building. Converting an existing building or part thereof into apartment. Basically, this will be come under or this will come under the redevelopment of the building. Then development of a land into plot or apartment as the case may be. In this case, basically when a land piece of parcel of land is subdivided and plots are made and the plots are sold, for that also it is called as real estate project. Now, what when those kind of structure, building or plots are made can be considered as a real estate project is the second question. When those plots or buildings are made or constructed, if the object of it is to sell those building or the plot or the apartment, only then it will come within the definition of real estate project, not otherwise. And real estate project will also include development work, which is defined under section 2, subsection T of that. Then all improvement and structure thereon on and all easement rights and appurtenance belonging thereto. This is very vital or important part of the definition. Because what happens, it's not only the construction of building, it's not only construction as that flat. There are many other things which are required for enjoying that property properly, that flat property. That will be a lot of peripheral things which requires to be developed with that. It could be an internal road, it could be the garden, it could be the clubhouse, depending upon the kind of project it is. So, to the definition of real estate project encompasses everything which could cover a development of a project. So, it is not limited to any particular thing. Everything which is required to enjoy the particular project or the particular flat is included in the definition of the real estate project. Now, whole object of RERA is there should be a transparency and to protect the interest of the buyer. To achieve that object, various provisions have been made in the RERA. One of the provision which is made is that registration of the project. Under section 3, all projects are required to be registered, which are within the planning area. So now all projects are required to be registered, which are in the planning area. So first we have to understand what is planning area. Planning area means area or a development area or a local area which is defined in section 2ZH. Area by whatever name called or any other area specified as such by appropriate government or any competent authority, and includes any area designated by the appropriate government or the competent authority to be a planning area for future planned development under the law relating to town and country planning for the time being in force as revised from time to time. So basically, planning area means there is some authority who has made some plan and who is implementing those plan. Is in basic, in brief understanding. It will include, or rather, it includes basically the municipal corporation, maybe city council, depending upon which the area it is located, corporation. So whatever it is, the concerned local authority can be called as, in the brief, a planning authority. Like Mumbai, outside Mumbai, there is also MMRDA. Like outside Pune, there is PMRDA. So different authorities which are basically are planning authorities and which controls the development of the property, the rules and regulation which are implemented by those authority. So that is a planning area. So any project which is in the planning area, for that registration of project is required. Please mark my word here, what it says, that registration of the project is required under the RERA. Even if registration is not required, according to me, it's my opinion, it can be said RERA is not applicable. RERA will be applicable, only registration will not be mandatory. But today, the view which is taken by the real estate authority is that only project to which RERA is registered, only them RERA is applicable. Others, if it is not registered project, they don't entertain any complaint. So now coming back to section 3. Section 3 starts with a non-abstentive clause. Not to advertise, basically non-obstructive clause, which says not to advertise, market, book, sell or offer for sale any plot of land without first registering the project with the real estate regulatory authority. So unless a project is registered, it cannot be marketed. No promotional event of the project can be done. So that is the first part which is required, is registration of the project. The section 3 also having a transitional provision for ongoing project. As you are aware that this act was enforced or rather notified on 1st of May 2017, many projects were ongoing project. So those also were required to be mandatory registered. For them, a 3 months window period was given to register the project. But now that is gone, that has become, section has become redundant. Even in the area of planning authority, where there is a planning area, the authority with the consent of the local authority can make registration of the project mandatory, and if it is registered, the rules and regulation of this act will apply. It means The rules and regulation for registered project means they have to submit regularly the updated reports, progress of construction, withdrawal of money, all those things will have to be submitted to the authority as per the process which is described under the law. Thus, that does not mean that only registered project, again I am repeating, will RERA will be applicable. No, I am totally disagreement with that thing. Now, as I told, there certain projects are exempted from the registration. A project which is on 500 square meter of land or where there are less than 8 apartments does not require registration. In all phases, that means if project is being developed in more than one phases, in that case, registration will be mandatory if that threshold limit crosses of 500 square meter or 8 apartment. In that case, project registration will be mandatory. Then, in respect of project where before the commencement of act has received completion certificate, I think this is something which requires consideration, because what the act says is that the project which has already received completion certificate will not require the registration of the project. Right, fair enough, and it's rightly so. But even the project after commencement of the act which has received completion certificate should not require registration. The reason behind that is that already project is completed. The project has received occupation certificate. If you see, the object of registration is that number one is there should be a proper disclosure and transparency by the developer while registering the project. This is a case in which already project is completed, everything is ready, this is the project is, so buyer is aware what is it, this is what I am going to get, this is what I am paying for. But when project is ongoing, things are different. You don't know, developer used to show something else and sell something else. This used to happen. To protect that interest, protect that issue, we have made it project which is ongoing a compulsory. But this doesn't give that or interpretation. It plain interpretation is that if on the date of commencement, if a completion certificate is there, project does not require registration. It will, the proper interpretation of the section should have been there. The completed project will not require certificate. Why? Suppose a project is complete, a promoter has developed the project without selling anything, without doing any marketing activity, without doing anything, and then he starts selling that. If you say that that requires registration, no problem. Keep a separate kind of format for that to make it register project. But at present, as per the existing format, where you have to give detail of the project, when project will be completed, what is the status at present, all those things has got no meaning today when the project is completed. But will that mean that registration RERA Act will not be applicable? It will be applicable, because tomorrow suppose a promoter completes a building and does not fulfill his obligation like formation of the society, conveyance, who is going to implement? He will say that because RERA is not applicable, he has no obligation. That cannot be so. That cannot be so. So according to me, one is that completion, if project is completed, RERA is applicable, but registration is not required. Then, in case of redevelopment, where developer doesn't intend to sell any of the flat, certainly if it's redevelopment and no flats are being sold, then it is not required. The registration is exempted. Thereafter, section 4 deals with the process to be followed for registration of the project. It, as the object of RERA is very clear, that there has to be transparency when the promoter promotes his project. The fund which is paid or the payment which is made by the flat purchaser to the promoter should be utilized in the manner for which it is paid, like the amount which is paid should be used for construction of the building and not to be diverted. So, keeping that in mind, various provisions are made, which is taken care at the time of registration of itself. One of the provision will come to it is depositing 70% of the flat consideration into separate account and to be used for construction and the land cost. So with that, let's see what is the process for registration of the project. Rather, we are right now going only through the section 4, which talk about the registration of project and what it requires. The registration of project is a two-step process. In one step, it's a registration of the promoter, and in the second step is registration of the project. First step, if you after you pass first step, then second step comes, because promoter will be having a multiple project. So once he register himself as a promoter, then he will have a separate project. You have to keep adding the project which is registered. That we will discuss when we are discussing the registration of the project. The promoter, while registering, as I told, first step is registration of promoter. Then next step is make you filing an application. These are all online process. All applications are online process. You have to give detail about the project in that online step. For if you have form, you have to go one by one, keep filling the forms, the requirement which they ask, the document which are required. All those things has to be filled online or uploaded online, and then projects will, then you have to make a payment, then there will be scrutiny. So first is that, as I told you, is detailed information about the enterprises. It could be a registered partnership, it could be LLP, it could be company, or it could be sole proprietor also. So first is who is the promoter, then what project promoter has done up till now, that is second part, and whether any cases pending about the past project will also have to be disclosed. Then comes the project, the concerned project which is being registered. In respect of that, you will require a copy of approval commencement certificate from the competent authority or the local authority, whosoever is the authorized to give the permission. Then development plan, detailed location of the property. Detailed location will have to be given by latitude and longitude where the property exactly is. Then along with that, the pro forma of all document like allotment letter, agreement for sale, and conveyance deed also has to be submitted. But unfortunately, in state of Maharashtra, the conveyance deed is not taken. It's not made a part of document at the time of registration of the project, and without that, project can be registered. According to me, even the apartment owner, the flat purchaser, is also entitled for conveyance of his flat as per the RERA. We will do separate video for that. And already I have written a lot on that topic. So these are the document which has to be submitted along with the at the time of submitting the registration of the project. Then detail of apartment which are available for sale. Who are the real estate agent for the project? Contractor, architect, and all stakeholder. Then at the time of project, a promoter also has to file an affidavit. This is one of the most crucial element, I will say, when thing is in respect of promoter. Because in that is an opportunity a promoter gets to disclose about his project properly, what his project is, and how he is going to develop that project. Because otherwise, there is no opportunity he gets when particularly buildings are developed in a phases to explain his project properly, and then tomorrow prevent the litigation which he may land up, because promoter flat purchaser will say this was not disclosed, purchaser will say promoter will say it was disclosed. So this is the opportunity, put everything in this affidavit which has to be mandatorily filed. In that affidavit you also have to tell about the detail of the dispute or the litigation going on, if there is a mortgage or charge, that mortgage or charge has to be given on in that this thing. Then time completion within which the project will be completed. So all those things have to be given in that affidavit, which is to be submitted at the time of registration of the project. Further undertaking also has to be given that all the pending permission or approval also will be taken by the promoter. As I told, these are all web application, web-based registration process. So once you fill all the columns in the form which is there online and submit all the document, you will have to pay the fees. I think the fees is around 10 rupees per square feet. It's working out something like that. Then you will get a notification that application has been made. Once application is made, the authority will scrutinize that application. Then if their concern objection will have to be addressed and removed, and thereafter project will be registered and you will be given a project registration certificate. In that, the registration number will be there and date of completion of the project will be there. The date of completion of the project is as whatever you are stated in the declaration of affidavit. But if it is some wild period given, suppose 100 years to complete the project, it will not be accepted. A reasonable time of period should be given for registration for the completion of project. The authority will accept it. Suppose now today in 2023 you are registering project. If it's a 5-8 or 5-8 floor building, if you write 3 years, 5 years, it will be accepted. But if you write it's going to take 100 years, 50 years, it will not be accepted. They will not accept it. So, reasonable period, whatever you write in a declaration of affidavit, it will be accepted. The registration has to be given within a period of 60 days. If it is not given within a period of 60 days, then there will be it will be considered as deemed registered project. If project is not registered, it's a rejected application, then authority will have to give an opportunity of being heard. Only thereafter authority can reject the application. As I told, deem registration, if within 30 days, if registration is not to not completed, if authority doesn't respond to your application, then it's a deemed registration. Then within 7 days after completing 30 days, you will be entitled for certificate of registration. As I told, validity of registration is the period which you have mentioned in a declaration or the application at the time of application, and that will be reflected in the registration certificate. That is a period of validity of of the real estate project. Then that is a validity period. After that validity period, if so required, the authority have a discretion on making an application to extend that period for 1 more year for reason which is mentioned if it is a due to force majeure. And force majeure is also defined under section 6, is defined as war, flood, drought, fire, cyclone, earthquake and any other natural calamity which affect the construction of the building. We had this issue during the COVID. During the COVID, authority had extended the time period, and that period was extended from time to time. Further, the 1 year period which is stated in the section 6 is not valid, and Bombay High Court has itself struck down that it clearly stated that it is not 1 year period. If so required, reason if recorded, a period can be extended for any number of period depending upon the circumstances. So that cap of 1 year period is not no more applicable under section 6. As I told, the whole object of registration is transparency. For that purpose, whatever requirement is done will be whatever requirement is there will be or it is captured in the registration process, and after everything is done the project will be registered for the period which it is valid. So this was a presentation on the registration of the project. If you have any query, you can raise your query in the comment box. We will be happy to answer it, and we will answer it. And if you want to know these topics or any topics under RERA, it's my invitation or request to attend the mastery in RERA, where you will become real master after completing that project, those courses. And if you want to know more about it, you can connect with the numbers which is given over here. With this, I am stopping this video, taking your leave, and I'm sure you might have liked this video. And don't forget to press like button and say like to it, and subscribe to this channel. And so I'm taking your leave. Bye bye. Take care. Bye bye.